Are Trudeau's gun bans racist? Well, yes, but probably not for the reasons you're thinking. Let's have a look. Welcome back to the channel. So today we're going to be discussing the core fundamental problem with Trudeau's regulatory gun bans, which were done unlawfully through an order in council. The first of these bans happened on May 1st, 2020, where they banned over 1,500 models of hunting and sporting firearms. And again, just a couple weeks ago, on December 5th, where Trudeau added another 324 firearms to the list. The bulk of these firearms were a bunch of black scary rifles, including the ever-popular and equally infamous AR-15. However, what a lot of people don't know is that on December 9th and 10th, the CCFR, along with a number of other interest groups, were the Federal Court of Appeals to have these unlawful gun bans overturned. And for what it's worth, it actually went better than I thought it would. The three federal justices were made aware of some of the bigger flaws regarding the ban, and when these justices asked the government lawyers about said flaws, they often had weak answers, or even in a few instances, they failed to produce any answers at all, which is, that's pretty huge for us. And if this is the first you're hearing about any of this, I have a whole series breaking down the first round of court with Justice Kane, detailing why she handed down a negative ruling and why she was also wrong to do so. And this video itself isn't going to be a breaking down of the events at the Federal Court of Appeals, but rather one thing that I felt that neither side really addressed. And that is the issue of why we needed to ban these so-called assault-style firearms in the first place. In the Order in Council, it very clearly says that these firearms are too dangerous because they're based on military designs, and therefore they increase the severity of mass shootings. And this is due to the inherent deadliness of such military designs. But for anyone who knows anything about firearms, that really doesn't make any sense. Not that military firearms are incapable of hurting people or anything, but simply stating that a particular firearm is based on a military design alone, that doesn't actually tell you anything about the capabilities of the firearm. And I felt that was an opportunity that the applicant's lawyers really failed to pounce on at appeal. And then, during day 2 of the appeal, when the government's lawyers had their turn to present their case, one lawyer in particular said over and over that the reason that these regulations needed to be so broad and that the word variant needed to remain undefined was to prevent gun companies from exposing loopholes in the regulations. And he said it over and over. Loopholes, loopholes, loopholes. The loophole being that even if they do ban assault-style rifles, if they then don't also ban the variants of assault-style rifles, and if they have to define what a variant actually is, then companies could just manufacture something with almost identical capabilities, but simply doesn't originate from a military design. Which I thought was a rather curious thing for them to admit to. After all, the very core of their Order in Council to begin with was the fact that the military design itself was the thing that made the firearm dangerous. Surely then it would be okay to manufacture a black, scary-looking semi-automatic firearm so long as it can't trace its lineage back to a military firearm, right? Well, according to the government's own lawyers, it wouldn't be, meaning that this is a direct and irrevocable admission from the government's own legal team that the focus of the regulations and the Order in Councils itself is a farce. They openly admit that whatever it is that makes a firearm dangerous, it actually has nothing to do with the militariness or the assaultiness of a firearm. If it was, then there would be no way for them to be claiming any supposed loopholes regarding this topic. And this is even supported by the new list which came out a week ago on December 5th. After the sweeping bans on May 1st, 2020, and the focus on banning firearms based on their military origins, tons of entrepreneurial Canadian firearm companies began manufacturing totally unique hunting and sporting firearms, which legitimately have no military origins. Yet, despite all of that, we see in the new list tons of families of one. These are totally unique firearms which were made to be compliant with the idea of not originating from a military design or lineage. If the Order in Council claims were at all based in reality, not originating from a military design or lineage should have been enough to make these firearms safe. But the Liberals didn't think so. But what does any of this have to do with racism? Well, first off, I want to be very clear about what I mean by that. And I don't mean the lazy answer that most of these firearms happen to be black, although many do come in multiple colors. And I also don't mean that these gun bans somehow disproportionately affect people of certain ethnicities. I mean, they might, but I have no evidence to suggest anything like that. I mean racist in like a very pure sense. And we all know that racism is inherently wrong. We ought to base our judgment towards people based on their merit and not based on the color of their skin. And most importantly, we know to do this not just because it's unfair, but also because it's untrue. There are no merit-based observations to be made based on someone's skin color or ethnicity. So where does one's skin color originate? Well, it's the result of genetics. And where do people get their genetics from? That comes from their parents. And where did their parents get their genetics from? Well, of course, from their parents, and their parents, and their parents, all the way up and so on. So in short, you get your genetics from your family tree. You might even say that your genetics are the result of your lineage, which is also very explicitly what these gun bans focus on. It focuses on identifying what the liberals have called heads of families, and then banning anything they can genetically link to that family tree. At Justice Kane's trial, Mr. Murray Smith even directly testified that the primary ingredient in determining what a variant is the lineage of the firearm. And he had this to say: "The important criterion in establishing whether a firearm is a variant or not is the lineage of the firearm, and that is whether it is derived from the original firearm or not." So as you can see, the focus of the bans is to identify and ban firearms based on their genetics, which is also why these bans feel so arbitrary and just random. It's because they are. These firearms were banned based on Trudeau's go-to play, identity politics. It's literally racism to its very core. And we all know that any particular person should be judged based on their merits and not of their family or lineage. And I would say the same is true of firearms. If this were truly about public safety, the firearms would be judged based on the merits of the firearm and not of what family or lineage you can genetically tie the firearm to. A meritocratic analysis of firearms revolves around its capabilities, whereas a lineage-based analysis simply does not. And to really showcase this point, let's take a look at the SIG MCX family of firearms, which were banned in 2020. Owing to its popularity and reliability on the civilian market, law enforcement eventually also picked it up. And shortly after the 2020 ban, the US military adopted it as a part of their Next Generation Squad Weapon program, their NGSW program. And the US military has it chambered in a brand new cartridge, 277 Fury. But most civilian and law enforcement models are typically chambered in the traditional 5.56, and it has also seen some limited use in special forces groups around the world, also usually chambered in 5.56. So there are assault rifle versions of the MCX equipped with a select fire trigger system, which are not legal in Canada for civilians and never have been. And there are also semi-automatic assault-style versions, which were lawful for use in Canada before the ban. However, because they have focused on lineage, families, and variants, both of these firearms are equally dangerous so far as the rational in the Order in Council is concerned, even though both of these firearms have significantly different capabilities in terms of their fire rates and lawful magazine capacities here in Canada. But it doesn't just stop there. They also make the SIG MCX in a pellet gun variant. Among these air rifles, they also have a variant which is chambered in .22 caliber pellets, meaning it is the same caliber as our assault-style rifles and our assault rifles. And we can also tell that legally it's a variant under the Liberals' definition, because there are advertisements calling it a variant. Which, if you remember from Mr. Smith's testimony in Kane's ruling, a firearm will be a variant simply if it is marketed as such. And SIG themselves even declare that these air guns are, quote, based on the original designs of the SIG MCX, end quote. Now you might be sitting there saying, that's all well and good, but they're just air guns. They're not real rifles, right? Actually, no. These pellet guns are designed to fire their pellets at ranges between 600 and 800 feet per second, meaning that so far as the law is concerned, these are firearms. Real firearms. You need a PAL in order to have one, and these air rifles are even registered on the firearms reference table as non-restricted firearms, although that registration is now incorrect as a result of these regulations. The RCMP and the Specialized Firearms Support Service don't appear to have noticed yet, but this pellet gun is now a prohibited firearm as a result of the Order in Council. So now we have 3 firearms: military assault rifles, civilian sporting rifles, and pellet guns, which are all prohibited under these regulations for the same singular reason. And hopefully this doesn't need much explanation, but these three firearms obviously differ vastly in their capabilities. However, at least so far as the Order in Council is concerned, they're all prohibited firearms because they're all genetically related to each other. They're part of the same family, and they share the same lineage. But clearly, a pellet gun is not a serious threat to public safety, which can increase the severity of mass shootings. It's not even capable of such a feat. And to be clear, it's not a toy. It wouldn't be a funny prank to shoot your buddy with it as if it were, airsoft or paintball or whatever, but it's equally untrue to say that this air gun would be capable of injuring, immobilizing, or killing humans in large numbers within a short period of time, as the Order in Council claims that it is. And this is because, even though it is genetically related to other MCX rifles, that doesn't mean it has automatically inherited the capabilities of those rifles. Focusing on families and lineages of firearms is demonstrably devoid of merit, just as racism is, and for precisely the exact same reasons. And there are many different legal directions you could take from this, from criticisms over arbitrariness or overbroadness, to a direct incoherency of the regulation's own internal reasoning, which would contradict the reasonableness standard as laid out in the Supreme Court precedents of Vavilov. Which is why I think it's so unfortunate that the applicants opted to not dive into this issue, either during Kane's review or on appeal. There are plenty of other places in the Order in Councils which are just clearly devoid of any merit, such as the claims that the firearm's popularity or modernity somehow make it more dangerous. It just doesn't. And then the issues regarding sustained rapid fire are also based on lies. And such things were brought up at appeal, and the justices seemed receptive to it, but I also feel like these criticisms were a little lackluster as well. They successfully made the points disproving concerns over modernity and popularity, adding to the dangerousness of a firearm, but they left the criticisms regarding sustained rapid fire open-ended and unanswered, when in fact, it is answerable. That being said, I think we actually have a fair chance of winning the appeal anyway, if I'm being honest. It was very clear that Justice Kane either didn't understand or didn't care to understand much of the applicant's arguments when they were presented to her, but when I watched the appeal, our three justices actually seemed to hear and understand many of the concerns and criticisms that were brought up, and the government's lawyers just didn't have great answers to a lot of these problems. But the fundamental issue of banning these firearms based on racism or identity politics was never discussed, and I feel like it was a missed opportunity. So I'm still not sure if I'm going to do a video discussing the case. Runkle of the Bailey has said he's going to do one, and normally when he and I release similar videos, mine just get buried. Which, fair enough, he is much bigger than I am. So owing to that, and because he's a legitimate lawyer, I think I'm going to wait and see what he has to say on the matter before deciding whether or not I make a video on it. I feel there's not much sense in both of us making almost identical videos on a single subject. As far as when we can expect a ruling, that's actually kind of interesting. Rod Giltacker from the CCFR had originally said it could be a few months, or maybe even as much as 6 months to a year, which, honestly, I thought that was a bit high. But this week in the CCFR's newsletter, it suggested a decision could be coming in the next several weeks. So we may not have to wait all that long to hear about it. I know there are a lot of, naysayers and whatever out there who believe that it's hopeless, but a lot of these people really haven't looked at the case or at the statute. Gun control itself is a bit of a, a 1 step forward, 3 steps backwards battle in Canada here. But the law is actually on our side for this one. And I, for one, am curious to see what the justices have to say about it. If any of you actually watched the Federal Court of Appeals remotely, let me know what you thought about it down in the comment section below. I thought day one was pretty brutal, especially the first half of day one. But I felt like Christine Genereux was a bit of a turning point for us. And then on day 2, the government's own lawyers made it very clear on their own, without any extra help from our side, just how inadequate their case actually is. And the justices picked up on that. So let me know what you think. All that being said, I'd like to thank you all for watching, and we'll see you in the next video.